Hello and welcome to our show, 60 Seconds with Sergio. I'm your host, Sergio Cabanas, attorney at law here in Florida. Thank you for joining us today. Today's question is, Sergio, my divorce or paternity case has already been completed. However, now I want to move away and start life over again somewhere else. But the other parent of my child is refusing to allow me to move. Can I move without his or her permission? Of course, the whole idea of concluding a divorce or paternity case is for both parties to move on with their lives. This includes having the freedom to move on with life as you like. However, there's an overriding consideration when it comes to cases involving minor children. The law basically provides both parents with the right to have time sharing with their minor children to the extent possible. This is a fundamental right that's recognized by the law. Furthermore, neither side should deprive the other of having that time sharing with the children by moving away. On the other hand, the law also understands that life goes on, and there will be times when one or both parents need to move, such as for financial reasons or new relationships, etc. So the law tries to balance these competing interests by allowing the parties to move as needed, but not interfere with the other parent's right to time sharing. So, as a general rule, either party is allowed to move, but not more than 50 miles from the residence that the child had at the time of the last court order dealing with time sharing, or not more than 50 miles away from the other parent's current residence. The 50 miles, by the way, is measured by a straight line, not by a destination of the road. If one of the parties wants to move more than the 50 miles away, the law calls the move a relocation. The relocating parent has to try to reach an agreement with the other parent for the relocation. If an agreement is reached, it must be in writing and it should be filed and approved by the court. If the other parent does not agree, the relocating parent must then file a petition to relocate with the court. The other parent must then respond within 20 days through the court system. If no response is filed, then the judge will generally allow the relocation. If a response is filed on time that objects to the relocation, the relocating parents must go to court and get permission from the judge before relocating. The relocating parent has the initial obligation of proving that the relocation is in the best interest of the child beyond the preponderance of the evidence. Then, the burden shifts to the non-relocating parent that the relocation is not in the child's best interest. The law provides a list of factors that the court can use to decide whether to allow the relocation. I cover those factors in a separate video. I hope this short video provided you some guidance about whether you can move with your minor children after a divorce or paternity case. Thank you again for joining me today, and as always, stay informed so you can stay strong.